Hello everyone, hope you are well. We are going to discuss about the Contract Act 1872, Act number IX of 1872. So here we go. Preamble, where is it is expedient to define and amend certain parts of the law relating to contracts, it is enacted as follows. Preliminary, short title. This act may be called the Contract Act 1872. Extent commencement. It extends to the whole of Bangladesh and it shall commended into force on the first day of September 1872. Enactments repealed. Nothing herein contained shall affect the provisions of any statute, act, or resolution not hereby expressly repealed, nor any uses or custom of trade, nor any incident of any contract not inconsistent with the provisions of this act. Interpretation clause. In this act, the following words or expressions are used in the following senses unless a contrary intention appears from the context. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstentions, he is said to make a proposal. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. The person making the proposal is called the promisor and the person accepting the proposal is called the promisee. When at the desire of the promisor, the promisee or any other person has done at, abstain from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstentions or promise is called a consideration for the promise. Every promise and every set of promises forming the consideration for each other is an agreement. Promises which form the consideration or part of the consideration for each other are called reciprocal promises. An agreement not enforceable by law is said to be void. An agreement enforceable by law is a contract. An agreement which is enforceable by law at the option of one or more of the parties thereto but not at option of other or others is a voidable contract. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Chapter 1 of the Communication Acceptance and Revocation of Proposals. Communication Acceptance and Revocation of Proposals. The communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptances respectively are deemed to be made by any act of omission of the party proposing, accepting, or revoking by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of communicating it. Throughout this act, except otherwise provided, the words Bangladesh, Taka, and Penal Code were substituted for the words Pakistan or East Pakistan. Communication when complete. The communication of a proposal is complete when it comes to knowledge of the person to whom it is made. The communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. As against the acceptor when it comes to the knowledge of the proposer. The communication of revocation is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it. As against the person to whom it is made when it comes to his knowledge. Illustrations. The proposes by letter to sell a house to B at a certain price. The communication of the proposal is complete when the B receives the letter. B accepts a proposal by a letter sent by post. The communication of the acceptance is complete as against A when the letter is posted, as against B when the letter is received by A. A revokes his proposal by telegram. The revocation is complete as against A when the telegram is dispatched. It is complete as against B when B receives it. B revokes his acceptance by telegram. B's revocation is complete as against B when the telegram is dispatched and as against A when it reaches him. Revocation of proposals and acceptances. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor but not afterwards. Illustrations. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance, but not afterwards. B may revoke his acceptance as any time before or at the moment when the letter communicating it reaches the but not afterwards. Revocation how made? A proposal is revoked by the communication of notice of revocation by the proposer to the other party by the lapse of the time prescribed in such proposal for its acceptance, or if no time is so prescribed by the lapse of a reasonable time without communication of the acceptance, by the failure of the acceptor to fulfill a condition precedent to acceptance, or by the death of insanity of the proposer if he fact or his death or insanity comes to the knowledge of the acceptance before acceptance. Acceptance must be absolute. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified, be expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes the manner in which it is to be accepted and the acceptance is not made in such manner, the proposer may within a reasonable time after the acceptance is communicated to him insist that his proposal shall be accepted in the prescribed manner and not otherwise, but if he fails to do so, he accepts the acceptance. Acceptance by performing condition or receiving consideration. Performance of the condition of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered with a proposal is an acceptance of the proposal. Promises express and implied. Insofar as the proposal of acceptance of any promise is made in words, the promise is said to be expressed insofar as such proposal or acceptance is made otherwise than in words. The promise is said to be implied. Chapter 2 of Contracts, Voidable Contracts and Void Agreements. What agreements are contracts? All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in Bangladesh, and not hereby expressly repealed, by which any contract is required to made in writing or in the presence of witnesses, or any law relating to the registration of documents. Who are competent to contract? Every person is competent to contract who is of the age of majority according to the law which he is subject, and who is of sound mind and is not disqualified from contracted by any law to which he is subject. What is the sound mind for the purposes of contracting? A person is said to be a sound mind for the purpose of making contract if at the time when he makes it, he is capable of understanding it and of forming relation judgment at it so its effect upon his interest. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Illustrations: the patient in a lunatic asylum who is intervals of sound mind may contract during those intervals. A sane man who is delirious from fever or who is so drunk that he cannot understand the terms of contract or form relation judgment as it to its effect on his interest cannot contract with such delirium or drunkenness lasts. Consent defined. Two or more persons are said to consent when they agree upon the same thing in the same sense. Free consent defined. Consent is said to be free when it is not caused by coercion as defined in section 15, or under influence as defined in section 16, or fraud as defined in section 17, or misrepresentation as defined in section 18, or Mistakes subject to the provisions of sections 20, 21 and 22. Consent is said to be so called when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Coercion defined. Coercion is the committing or threatening to commit any act forbidden by the penal code or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing any person to enter into an agreement. Explanation. It is the immaterial whether the penal code is or is not on force in the place where the coercion is employed. Illustration. On board an English ship on the high seas causes B to enter into an agreement by an act amounting to criminal intimidation under the penal code. Afterwards sues B for breach of contract at Chittagong. A has employed coercion although his act is not an offence by the law of England and although section 506 of the penal code was not in force at the time when or place where the act was done. Undue influence defined. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses the position to obtain an unfair advantage over the other. In particular and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of another, where he holds a real or apparent authority over the other or where he stands in a fiduciary relation to other or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness or mental or bodily distress. Where a person who is in position to dominate the will of another enters into a contract with him and the transaction appears on the face of it or on the evidence adduced to be unconscionable. The burden of providing that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Nothing in this subsection shall affect the provisions of section 111 of the Evidence Act 1872. Illustrations. A having advanced money to his son B during his minority upon B coming of age obtains by misuse of parental influence a bond from B for greater amount than the sum due in respect of the evidence. A employs undue influence. A man enfeebled by disease or age is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs undue influence. A being in debt to B, the moneylender of his village, contracts a fresh loan on terms which appear to be unconscionable. It lies on B to prove that his contract was not induced by undue influence. A applies to a banker for a loan at a time when there is stringency in the money market. The banker declines to make the loan except an unusually high rate of interest. A accepts the loan on these terms. This is a transaction in the ordinary course of business and the contract is not induced by undue influence. Fraud defined. Fraud means the inclusion of any of the following acts committed by the party to a contract or with his conveyance or by his agent with intent to deceive another party there or his agent or to induce him to enter into the contract. The suggestion as the fact of which is not true by one who does not believe it to be true. The active concealment of a fact by one having knowledge or belief of the fact. A promise made without intention of performing it. Any other act fitted to deceive. Any such act or omission as the law especially declares to be fraudulent. Explanation. Mere silence is as to facts like to affect. The willingness of a person to enter into a contract is not fraud unless the circumstances of the case are such that regard behind being had to them. It is the duty of the person keeping silence to speak or unless his silence is in itself equivalent to speech. Illustrations. A sells by auction to B a horse which A knows to be unsound. A says nothing to B about the horse's unsoundness. This is not fraud in A. B is A's daughter and has just come of age. Here the relation between the parties should make at A duty to B if the horse is unsound. B says to A, if you do not deny it, I shall assume the horse is sound. A says nothing. Here A's silence is equivalent to speech. A and B being traders enter upon a contract. A has private information of a change in prices which would affect B's willingness to produce the contract. A is not bound to inform B. Misrepresentation defined. Misrepresentation means they includes the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true. Any breach of duty which without an intent to deceive gains an advantage to the person committing it or any one claiming under him by misleading another to his prejudice or to be prejudice of any one claiming under him, causing however innocently a party to an agreement to make a mistake as to a substance of the thing which is the subject of agreement. Voidability of agreements without free consent. When consent to an agreement is caused by coercion, fraud or misrepresentation, the agreement is contract voidable at the option of the party whose consent was so caused. A party to a contract whose consent was caused by the fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the representations made had been true. Exception: if such consent was caused by misrepresentation or by silence, fraudulent within the meaning of section 17, the contract never the unless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Explanation: a fraud or misrepresentation which did not cause the consent to a contract of the party on whom such fraud was practiced or to whom such misrepresentation was made does not render a contract voidable. Illustrations: A intending to deceive B falsely represents the 500 mounds of indigo are made annually at A's factory and thereby induces B to buy the factory. The contract is voidable at the option of B. A by a misrepresentation leads B erroneously to believe that 500 mounds of indigo are made annually at A's factory. B examines the accounts of the factory which show that 1,400 mounds of indigo have been made. After this, B buys the factory. The contract is not voidable on accounts of A's misrepresentation. A fraudulently informs B that A estate is free from encumbrance. B thereupon buys the estate that the estate is subject to a mortgage. B may either avoid the contract or may insist on its being carried out and the mortgage debt redeemed. B, having discovered a vein of or on the estate of A, adopts means conceal and does conceal the existence of the or from A thought as ignorance. B is unable to buy this estate at any under value. The contract is voidable at the option of A. A is entitled to success to an estate at the death of B. B dies. C, having received intelligence of B's death, prevents the intelligence reaching A, thus induces A to sell him his interest in the estate. The sale is voidable at the option of A. Power to set aside contract induced by undue influence. When consent to an agreement is caused by undue influence, the agreement is the contract voidable at the option of the party whose consent was so caused. Any such contract may be set aside either absolutely or, if the party who was entitled to avoid it, it has received any benefits thereunder upon such terms and conditions as to court may seem just. Illustration: A has sons has forged B's name to promissory note. B, under threat or prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on this bond, the court may set the bond aside. A money lender advances Taka 100 to B, an agriculturist, and by undue influences includes B to execute a bond for Taka 200. with interest at 6% per month, the court may set the bond aside, ordering B to repay the taka 100 with such interest as may seem just. Agreement void where both parties are under mistakes as to matter of fact. Where both the parties to an agreement are under a mistake as to matter of the essential to the agreement is void. Explanation and erroneous opinion as to value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. Illustrations. A agrees to sell B a specific cargo of goods supposed to be its weight from England to Chittagong. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of the fact. The agreement is void. A agreed to buy from B certain horse. It turns out that the horse was dead at the time of the bargain. Though neither party was aware of the fact, the agreement is void. A, being entitled to an asset for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact. The agreement is void. Effect of mistakes as to law. A contract is not voidable because it was caused by a mistake as to any law in force in Bangladesh, but a mistake as to law not force in Bangladesh has the same effect as a mistake of fact. Illustration. A and B make a contract grounded on the erroneous belief that a particular debt is bared by the Bangladesh law of limitations. The contract is not voidable. Contract caused by mistake of one party as to matter of fact. A contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to matter of fact. What considerations and objects are lawful and what not? The consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted it would defeat the provisions of any law or is fraudulent or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object in agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. Illustration. A agrees to sell his house to B for 10,000 taka. Here is B promised to pay the sum of 10,000 taka is the consideration for A promises to sell the house, and A's promise to sell the house is the consideration fee. B promises to pay the 10,000 taka. These are lawful considerations. A promise to pay 1,000 taka at the end of his 6 months. If C, who owes that sum to B, fails to pay it, B promises to grant time to C accordingly. Here the promise of each party is consideration for the promise of the other party, and they are lawful considerations. A promises for a certain sum paid to him by B to make good to B the value of ship if it is wrecked on uncertain voyage. Here is A promise the consideration for B's payment, and B's payment is the consideration for A's promises, and these are lawful considerations. A promises to maintain B's child, and B's promises to pay A 1,000 taka yearly for the purposes. Here the promise of each party is the condition for the promise of the other party. They are lawful considerations. A, B and C enter into an agreement for the division among them of gains acquired or to be acquired by them by fraud. The agreement is void as its object is unlawful. A promises to obtain for B an employment in the public service. B promises to pay 1,000 taka to agreement is void as the consideration for it is unlawful. A being agent for a landed proprietor agrees for money without the knowledge of his principal to obtain for B a lease of land belonging to his principal. The agreement between A and B is void as it implies a fraud by concealment by on his principal. A promises B to drop a prosecution which he has instituted against B for robbery, and B promises to restore the values of the things taken. The agreement is void as its object is unlawful. A's estate is sold for arrears of revenue under the provisions of an act of the legislature by which the defaulter is prohibited from purchasing the estate. B upon an understanding with becomes the possessor and agrees to convey the estate to A upon his receiving from him the price which B has paid. The agreement is void as it renders the transaction in effect a purchase by the defaulter and would so defeat the object of law. A, who is B's Mukhtar, promises to exercise his influence as such with B in favor of C, and C promises to pay 1000 taka to A. The agreement is void because it is immoral. A agrees to let her daughter to hire to B for concubinage. The agreement is void because it is immoral, so the letting may not be punishable under the penal code. Agreements void if consideration and objects unlawful in part. If any part of signal consideration for one or more objects, or any one or any part of any one of several considerations for a single object is unlawful, agreement is void. Illustration: A promises to superintend on behalf of B a legal manufacture of indigo and an illegal traffic in another articles. B promises to pay to A salary of 10,000 taka a year. The agreement is void. The object of A's promise and the consideration B's promise being in part unlawful. Agreement without consideration void unless it is in writing and on register, or is promised to compensate for something done, or is the promise to pay a debt beared by limitation law. An agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents, and is made on account of natural love and affection between parties standing in a near relation to each other, or unless it is the promise to compensate wholly or part in a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do, or unless it is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or especially authorized in that behalf to pay wholly or in part debt which the creditor might have enforced payment for, but for the law for the limitations of suits. In any of these cases, such an agreement is a contract. Explanation 1. Nothing is in this section shall affect the validity as between the donor and donee of any gift actual made. Explanation 2. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of a promisor was freely given. Illustrations: A promises for no consideration to give to B taka 1000. This is the void agreement. A, for natural love and affection, promises to give his son B taka 100. Puts his promises to B into writing and registers. This is the contract. A finds B's purse and gives it to him. B promises to give a taka 50. This is the contract. A supports B's infant son, B promising to pay as expenses in so doing. This is the contract. A owes B taka 1000, but the debt is beared by the Limitations Act. A signs a written promise to pay B taka 500 on account of the debt. This is the contract. A agrees to sell a horse worth taka 1000 for taka 10 as consent to the agreement was freely given. The agreement is a contract notwithstanding the inadequacy of the consideration. A agrees to sell a horse worth taka 1000 for taka 10. A denies that his consent to agreement was freely given. The inadequacy of the consideration is the fact which the court should take into an account in considering whether or not A's consent was freely given. An agreement in restraint of marriage void. Every agreement in restraint of the marriage of any person other than a minor is void. Agreement in restraint of the trade void. Saving of agreement not to carry on business of his good will is sold. Every agreement by which anyone is restrained or from exercising a lawful profession, trade or business of any kind is to that extent void. Exception 1. One who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer or any person delivers title to goodwill from him, carries on a like business therein, provided that such limits appear to the court reasonable regard being had to the nature of business. Exception 2 and 3, repealed by Section 73 and Second Schedule of the Partnership Act 1932. Agreements void for uncertainty. Agreements the meaning of which is not certain or capable of being made certain are void. The Contract Act 1872 agreements by way of which are void expectations in favor of certain prizes for horse racing. Section 29(4)(a) of the Penal Code not affected. Agreement by way of which are void and not suit shall be brought for receiving anything alleged to be owned on any wager or entrusted to any person to abide the result of any game or other uncertain event on which wager is made. This section shall not be deemed to render unlawful a subscription or contribution or agreement to subscribe or contribute made or enter into for or toward any plate prize or sum of money of the value or amount of 500 taka or upwards to be awarded to the winner or winners of any horse race. Nothing in this section shall be deemed to legalize any transaction connected with horse racing to which the provisions of Section 29(4)(a) of the Penal Code apply. Agreements collateral to wagering agreements void. All agreements knowingly made for further or assist the entering into, effecting or carrying out or to secure or guarantee the performance of any agreement void under Section 30 are void. No suit for recovery of money, commission, etc. in respect of void agreements. No suit or other proceedings shall lie for the recovery of any sum of money paid or payable in respect of any agreement void under Section 30(a) or any commission, brokerage fee or reward in respect of knowingly effecting or carrying out or aiding in effecting or carrying out of any such agreement or of any sum of money otherwise claimed or claimable in respect thereof, or any sum of money knowingly paid or payable on account of any person by way of commission, brokerage fee, reward or other claim in respect of any such agreement. Payment by guardian, executor, etc. in respect of void agreements not to be allowed credit. No guardian, executor, administrator, heir or personal representative of any minor or deceased person, as the case may be, shall be entitled to or allowed any credit in his account for or in respect of any payment made by him on behalf of such minor or deceased person in respect of any such agreement or any such commission, brokerage fee, reward or claim as is referred to in sections 30(a) and 30(b). Chapter 3 of Contingent Contracts. Contingent contract defined. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Illustration: a contract to pay B taka 10,000 if B's house is burned. This is a contingent contract. Enforcement of contracts contingent on an event happening. Contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. Illustrations: A makes a contract with B to buy B's horse if A survives C. This contract cannot be enforced by law unless and until C dies in A's lifetime. A makes a contract with B to sell a horse to B at a specified price. If C, to whom the horse has been offered, refuses to buy him, the contract cannot be enforced by law unless and until C refuses to buy the horse. A contracts to pay B a sum of money when B marries C. C dies without being married to B. The contract becomes void. Enforcement of contracts contingent on an event not happening. Contingent contracts to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not before. A agrees to pay B a sum of money if a certain ship does not return. The ship is sunk. The contract can be enforced when the ship sinks. When event on which contract is contingent to be deemed impossible if it is the future conduct of a living person. If the future event on which a contract is contingent is the way in which a person will act at an unspecified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time or otherwise than under further contingency. A agrees to pay B a sum of money if B marries C. C marries D. The marriage of D to C must now be considered impossible, although it is impossible that D may die and that C may afterwards marry B. When contracts become void which are contingent on happening of specified event within fixed time. Contingent contracts to do or not to do anything if a specified uncertain event happens within a fixed time become void if at the expiration of the time fixed such event has not happened or if before the time fixed such event becomes impossible. When contracts may be enforced which are contingent on a specified event not happening within fixed time. Contingent contracts to do or not to do anything if a specified uncertain event does not happen within a fixed time may be enforced by law when the time fixed has expired and such event has not happened or before the time fixed has expired. If it becomes uncertain that such event will not happen. Agreement contingent on impossible events void. Contingent agreements to do or not to do anything if an impossible event happens are void whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. A agrees to pay B 1000 taka if two straight lines should enclose the space. The agreement is void. A agrees to pay B 1000 taka if B will marry A's daughter C. C was dead at the time of the agreement. The agreement is void. Chapter 4 of the Performance of Contracts. Obligation of parties to contracts. The parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or executed under the provisions of this Act or of any other law. Promises being the representatives of the promissory in the case of the death of such promisors before performance unless a contrary intention appears from the contract. Effect of refusal to accept offer of performance. Where a promisor has made an offer of performance to the promisee and the offer has not been accepted, the promisor is not responsible for non-performance, nor does he thereby lose his rights under the contract. Every such offer must fulfill the following conditions. It must be unconditional. It must be made at proper time and place and under such circumstances that the person to whom it is made may have a reasonable opportunity of a certainty that the person by whom it is made is able and willing there and then to do the whole of what he is bound by his promise to do. If the other offer is an offer to deliver anything to the promisee must have a reasonable opportunity of seeing that the thing offered is the thing which is the promisor is bound by his promise to deliver. An offer to one of several joint promises has the same legal consequences as an offer to all of them. Effect of refusal of party to perform promise wholly. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct is his acquiescence in its continuance. Person by whom promise is to be performed. If it appears from the nature of the case that it was the intention of the parties to any other contract that any promise contained in it should be performed by the promisor himself, such promise must be performed by the promisor. In other cases, the promisor or his representatives may employ a competent person to perform it. Effect of accepting performance from third person. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. Devolution of joint liabilities. By whom contracts must be performed. When two or more persons have made a joint promise, then unless the contrary intention appears by the contract, all such persons during their joint lives and after the death of any of them, his representatives jointly with the survivor or survivors, and after the death of the last survivor, the representatives of all jointly must fulfill the promise. Any one of joint promisers may be compelled to perform. Each promisor may compel contribution, sharing of loss by default in contribution. When two or more persons make a joint promise, the promise may, in the absence of express agreement to the contrary, compel any one or more of such joint promisers to perform the whole of the promise. Each of two or more joint promisers may compel every other joint promiser to contribute equally with himself to the performance of the promise. Unless the contrary intention appears from the contract, if any one of two or more joint promisers makes default in such contribution, the remaining joint promisers must bear the loss arising from such default in equal shares. Explanation. Nothing in this section shall prevent a surety from recovering from his principal payments made by the surety on behalf of the principal or entitle the principal to recover anything from the surety on account of payments made by the principal. Effect of release of one joint promisor. Where two or more persons have made a joint promise, a release of one of such joint promisers by the promise does not discharge the other joint promisor or joint promisers, neither does it free the joint promisers released from responsibility into the other joint promisor or joint promisers. Devolution of joint rights. When a person has made a promise to two or more persons jointly, then unless the contrary intention appears from the contrary, the right to claim performance rests as between him and them, with them leading their joint lives, and after the death of any of them, with representative of such deceased person jointly with the survivor of survivors, and after the death of the last survivor with representatives of all jointly. Time for performance of promise, where no application is to be made and no time is specified. Whereby the contract a promisor is to perform his promise without application by the promisee and no time for performance is specified, the engagement must be performed within a reasonable time expression. The question what is reasonable time is in each particular case a question of fact. Time and place for performance of promise where time is specified and no application to be made. When promise is to be performed on certain day and the other promisor has undertaken to perform it without application by the promisee, the promisor may perform it at any time during the usual hours of business on such day and at the place at which the promisee ought to be performed. Application for performance on certain day to be at proper time and place. When a promise is to be performed on certain day and the promisor has not undertaken to perform without application by the promisee, it is the duty of the promisee to apply the promise. It is the duty of to apply for performance at a proper place and within the usual hours of business. Explanation: the question what is the proper time and place is in each particular case a question of fact. Place for performance of promise, you have no application to be made and no place fixed for performance. When a promise is to be performed without application by the promisee and no place is fixed for the performance of it, it is the duty of promisor to apply to the promisee to appoint a reasonable place for the performance of the promisee and to perform it at such place. Performance in manner or at time prescribed or sanctioned by promisee. The performance of any promisee may be made in any manner or at any time which the promisee prescribes or sanctions. Promisor not bound to perform unless the reciprocal promisee ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, no promisor need perform his promise unless the promise is ready and willing to perform his reciprocal promise. Order of performance of reciprocal promises. Where the order in which reciprocal promises are to be performed is expressly fixed by the contract, they shall be performed in that order, and where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of the transaction requires. Liability of party preventing event on which the contract is to take effect. When a contract contains reciprocal promises and one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from the other party for any loss which he may sustain in consequence of the non-performance of the contract. Effect of default as to the promise which should be first performed in contract consisting to reciprocal promises. When a contract consists of reciprocal promises such that one of them cannot be performed or that its performance cannot be claimed till the other has been performed, and the promisor of the promisee last mentioned fails to perform it, such promisor cannot claim the performance of the reciprocal promise and must make compensation to the other party to the contract for any loss which such other party may sustain by the non-performance of the contract. Effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before a specified times, and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence of the contract. Effects of such failure when time is not essential. If it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. Effect of acceptance of performance at time other than the agreed upon. If in case of contract voidable on account of the promisor's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than that agreed. The promisee cannot claim compensation for any loss occasioned by the non-performance of the promise at the time agreed, unless at the time of such acceptance he gives notice to the promisor of his intention to do so. Agreement to do impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent unlawful becomes void when the act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful. Where one person has promised to do something which he knew or with reasonable diligence might have done and which the promisee did not to be impossible or unlawful, such promisor must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. Reciprocal promise to do things legal and also other things illegal. Where person reciprocally promise firstly to do certain things which are legal and secondly under specified circumstances to do certain other things which are illegal, the first set of promises is a contract but the second is a void agreement. Alternative promise, one branch being illegal. In the case of alternative promise, one branch of which is legal and the other illegal, the legal branch alone can be enforced. Application of payment where debt to be discharged as indicated. Where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implying that payment is to be applied to the discharge of some particular debt, the payment if accepted must be applied accordingly. Application of payment where debt to be discharged is not indicated. Where the debtor has omitted to intimate and there are no other circumstances indicating to which debt the payment is to be applied, the creditor may apply it at his discretion to any unlawful debt actually due and payable to him from the debtor, whether it is recovery is or is not barred by the law in force for the time being as to limitation of source. Application of payment where neither party appropriates. Where neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, either they are or not barred by the law in force for the time being as to limitation of source. If the debts are equal standing, the payment shall be applied in discharge of each proportionally. Effect of novation, rescissions and alternation of contract. If the parties to a contract agree to substitute a new contract for it or to rescind or alter it, the original contract need not be performed. Promises may dispense with or remit performance of promise. Every promises may dispense with or remit wholly or in a part the performance of the promise made to him or may extend the time for such performance or may accept instead of it any satisfaction which he thinks fit. Consequences of rescissions of voidable contract. When a person at whose option a contract is voidable rescinds it, the other party thereto need not perform any promise therein contained in which he is promisor. The party rescinding a voidable contract shall, if he have received any benefit thereunder from another party to such contract, restore such benefit so far as may be to the person from whom it was received. Obligation of person who has received the advantage under void agreement or contract that becomes void. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it for the person from whom he received it. Mode of communicating or revoking rescissions of voidable act. The rescissions of voidable contract may be communicated or revoked in the same manner and object to the same rules as apply to the communication revocation of a proposal. Effect of neglect of promise to afford promise or reasonable facilities for performance. If any promisee neglects or refuses to afford the promisor reasonable facilities for the performance of his promise, the promisor is excused by such neglect or refusal as to any non-performance caused thereby. Claim for necessaries supplied to person incapable of contracting or on his account. Chapter V. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Reimbursement of person paying money due by another in payment of which he is interested. A person who is interested in the payment of money which another is bound by law to pay and who therefore pays it is entitled to be reimbursed by the other. Obligation of person enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as the bailey. Liability of person to whom money is paid or thing delivered by mistake of under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Chapter 6 of the consequence of breach of contract. Compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby which naturally arose in the usual course of things from such breach or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation not be given for any remote and indirect loss or damage sustained by reason of the breach. Compensation for breach of contract where penalty is stipulated for. When a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by the way of penalty, the party complaining of the breach is entitled, either or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be the penalty stipulated for. Explanation: a stipulation for increased interest from the date of default may be stipulation by the way of penalty. Exception: when any person enters into a bail, bond, reconnaissances, or the other instrument of the same nature, or under the provisions of any law, or under the orders of the government, gives any bond for the performance of any public duty or act in which the public are interested, he shall be liable upon breach of the condition of any such instrument to pay the whole sum mentioned therein. Explanation: a person who enters into a contract with government does not necessarily thereby undertake any public duty or promise to do an act in which publics are interested. Party rightfully rescinding contract entitled to the compensation. A person who rightly rescinds a contract is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract. Chapter 7 Sale of Goods. Chapter 8 of Indemnity and Guarantee. Contract of indemnity defined. A contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person is called a contract of indemnity. So that is it for today. Thanks for watching the video.